Hello friends, this is Dr. Sumiti Ahuja and I am Assistant Professor at Faculty of Law, University of Delhi. It's very interesting to see that although section 68 to 72 of the Indian Contract Act are dealing with the concept of quasi-contracts, but nowhere in the entire Indian Contract Act has this term been used or defined. But the principles which have been incorporated in all these sections, that is 68 to 72, they are based or they are resembling those relations which are created by or created under a contract. How? We will be proceeding to that, we will be discussing that one by one. But let us first start with the understanding as to what do we mean by the term quasi. In one of our previous sessions, I had told you this thing that most of the times the meaning is hidden in the legal terminology itself. So, we know what is a contract, but what do we mean by a quasi-contract? Quasi-contract is which is almost a contract, but it is still not a complete valid contract, and that is why it is quasi, right. So, certain relations resembling those created by contract. Now, the provisions relating to quasi-contract under the Indian Contract Act, they are headed as, this is the heading given to that chapter dealing with quasi-contracts, because I was just telling you that this term has not been defined anywhere in the Act, nowhere has it been used in these provisions under 68 to 72, but the heading which is mentioned there in that group of sections is that those provisions or those instances, if I may say, which have been highlighted under 68 to 72, they resemble those relations which are created by contract. That is why quasi, they resemble relations created by a contract, but still they are not valid contract, reason being that in order to be a valid contract, the Act provides for certain essentials as defined or as stated, if I may say. They have been defined under different provisions, but as they have been stated under section 10 of the Indian Contract Act. Then many a times law as well as justice demands that certain individual or certain person be required to conform, that is to obey an obligation even though he has not broken any contract nor has committed tort. What do we mean by this? We mean that, see, the relations which we are referring to under 68 to 72, that is what we are terming as quasi-contracts, they are neither, they do not, it is not like that a person is breaking some kind of a contract, nor is it like a tort has been committed. Why can't we say that a person has not broken a contract? Because no breach has taken place. Because when we say broken a contract, for that there is a requirement of a contract first. Herein no contract, and for that matter no agreement even is in existence. Because for a contract, first there should be an agreement in existence, and as we had discussed in our previous sessions, agreement is offer plus acceptance. So, here neither an offer is being made nor is that offer being accepted, right. And why can't we say a tort is committed? So, one aspect in which contracts and quasi-contracts, they have resemblance, or a point of similarity you can say, is that in case of quasi-contract also we are referring to relations between two parties. So, when one person's action has affected the interest of the other party, right. Whereas in case of torts, it is not like there are two parties. Basically, it is like you have a duty towards others, duty towards public at large, that you are not going to infringe or not going to injure anybody's legal right. Liability of this kind, liability we mean the liability in relation to a quasi-contract. So, liability of this kind is hard to classify. It is hard to classify because it is neither completely fulfilling the requirements of a valid contract, nor is it completely fulfilling the requirements of a tort. That's why it becomes hard to classify it. Partly it resembles liability under law of tort in as much as it arises independently of any contract. See, be it contract, be it a tort, for that matter be it a quasi-contract, they are all falling under the category of a civil wrong. That's why this statement here wherein we are saying that partly it resembles liability under law of tort in as much as it arises independently of any contract, and the remaining part resembles contract in as much as liability is owed only to one party and not to persons generally. This is the point of difference between a contract as well as a tort also, and similar is the situation in relation to a quasi-contract and torts, that liability in case of a quasi-contract is owed only to one party, whereas in case of tort it is owed to public at large, that is persons in general. Therefore, it can be accounted for either under an implied contract, that is although it is not fulfilling the conditions but still an implied contract, or under natural justice and equity for prevention of unjust enrichment. In our next slide, we would be proceeding to the discussion in relation to the theory of unjust enrichment, but for the time being just understand this thing that yes, there have been two types of theories, or if I may say two types of justification about the existence of or about the rationale of quasi-contract. One of them has been that it is an implied contract. Yes, it is not a complete contract, not fulfilling all the essentials of a valid contract, but it is considered like an implied contract. And on the other hand, then the other theory which was dealing with the rationale of quasi-contracts was theory of unjust enrichment. That is, you are getting benefited with something to which you are not entitled to, right. So, as you can see on your screens, the last statement I have written that although preferred rationale is prevention of unjust enrichment. So, whenever you will be studying about the concept of quasi-contracts and you will be studying about the basis, the rationale or the purpose behind the origin of this concept quasi-contract and its incorporation within our statutory law,